5 seconds to go. Start. This court in K. Narendra Supra in paras 29 and 30 held as under Section 20 of the Specific Relief Act 1963 provides that the jurisdiction to decree specific performance is discretionary and the court is not bound to grant such relief merely because it is lawful to do so. The discretion of the court is not arbitrary but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. Performance of the contract involving some hardship on the defendant which he did not foresee, while non performance involving no such hardship on the plaintiff is one of the circumstances in which the court may properly exercise discretion not to decree specific performance. The doctrine of comparative hardship has been thus statutorily recognized in India. However, mere inadequacy of consideration or the mere fact that the contract is onerous to the defendant or improvident in its nature shall not constitute an unfair advantage to the plaintiff over the defendant or unforeseeable hardship on the defendant. The principle underlying Section 20 has been summed up by this court by stating that the decree for specific performance is in the discretion of the court, but the discretion should not be used arbitrarily. The discretion should be exercised on sound principles of law capable of correction by an appellate court. Severe hardship may be a ground for refusing specific performance even though it results from circumstances which arise after the conclusion of the contract which affect the person of the defendant rather than the subject matter of the contract and for which the plaintiff is in no way responsible. It may not be out of place to state at this stage that in K. Narendra Supra there is a reference with approval to Chitti on Contracts 27th edition 1994 volume 1 at page 1296 where the passage quoted clearly indicates that one of the grounds for refusing specific performance, though they arise from circumstances post contract, are factors which affect the person of the defendant rather than the subject matter of the contract and to which the plaintiff is in no way a contributory. It is these personal circumstances of the defendant which this court has alluded to in the earlier part of this judgment while dwelling upon the issue of hardship under section 22b of the Specific Relief Act 1963. The discretion there being wide, it is certainly not limited to what is illustratively mentioned in the statute. At the cost of some repetition, it therefore deserves emphasis that circumstances of the plaintiff also are very relevant in the exercise of discretion to grant specific performance based on the parameters of hardship to the defendant. Even if we go by what Chitti had said in his book Chitti on Contracts, 27th edition 1994 referred to above, there is nothing which the defendants have been able to bring on record that the suit property is the only shelter available to them. It appears from the evidence on record that late Prabharanjan Das was not getting along well with his wife and son. His wife and son, that is, the defendants, were residing separately. It appears that they were residing at the parental home of the defendant number 1. It is only when Prabharanjan Das passed away that the defendants tried to take over the suit property. The learned counsel, appearing for the respondents' original defendants, vehemently submitted that the trial court failed to frame any issue whether the plaintiff was always ready and willing to perform his part of the contract. It seems that the learned counsel is under some misconception of fact that the trial court did not frame the issue as regards whether the plaintiff was ready and willing to perform his part of the contract. The trial court did frame the issue as regards readiness and willingness and answered in the affirmative, that is, in favor of the plaintiff. The High Court does not seem to have touched this issue at all. The High Court has not disturbed the findings recorded by the trial court on the issue of readiness and willingness. The plaintiff was always ready and willing to perform his part of the contract. In the overall view of the matter, we are convinced that the High Court committed an error in setting aside the decree passed by the trial court of specific performance. In the result, this appeal succeeds and is hereby allowed. The impugned order passed by the High Court is hereby set aside. However, we would like to restore the original decree passed by the trial court with a little modification. The trial court directed that the appellant herein, original plaintiff, shall pay the balance consideration of rupees 13,50,000 to the defendants, and upon receipt of the said amount, the defendants shall execute the sale deed in favor of the appellant herein, original plaintiff. In the facts and circumstances of this case, more particularly keeping in mind that the defendant number 1 is a widow and defendant number 2 is her minor son, we deem fit to enhance the amount to be paid towards the balance consideration to rupees 20 lakh. The decree of the trial court stands modified to the aforesaid extent. In short, the appellant herein, original plaintiff, shall pay an amount of rupees 20 lakh to the defendants, and upon receipt of the same, the defendants shall execute the sale deed in favor of the appellant, original plaintiff. The appeal stands disposed of in the aforesaid terms. Stop.